we're going to hear from Katie Townshend.
Thanks so much. I'd like to thank the Pipeline Safety Trust for inviting me to come to this conference today. As I think everyone has probably gathered at this point, the expertise I bring to the table is not in the area of pipelines or pipeline safety. It is in the area of press and public access to government records through state public records acts, as well as the Federal Freedom of Information Act, and access to civil and criminal judicial proceedings, as well as access to administrative proceedings. So that's some of the background I wanted to give you today. I think a good starting point when you talk about access generally, and whether it's access to administrative proceedings or what I like to call Article 3, but it's what we think of in the court system, judicial and civil proceedings, is with judicial or criminal and civil judicial proceedings, because that's where the rights really flow from. The Supreme Court has recognized a First Amendment right to attend criminal proceedings that's applicable to the press and the public. Lower courts have expanded that to include not only civil proceedings, but also documents that are filed in connection with criminal proceedings, as well as to civil proceedings, so civil litigation between private parties, essentially. The Supreme Court has also recognized a common law right of access to court records that has been expanded. Some lower federal courts view it as a First Amendment right, not simply a common law right. But that's really the starting point for any discussion of access to proceedings. Many of you are aware that there's been, since really the 1950s and especially since the 1970s, an explosion in administrative proceedings and administrative adjudications that take the place of a lot of criminal proceedings or even somewhat civil proceedings that would have previously been sort of waged in the courts. I don't have a lot of time, so I'm gonna kind of skip ahead. I was gonna talk a little bit more about the First Amendment right of access and the common law right of access, but I'll skip directly to access to administrative proceedings, since that's really what we're here to talk about. In a case that did not involve access per se, but actually involved whether or not a state could assert state sovereign immunity in an administrative proceeding, the United States Supreme Court quoted the Fourth Circuit as saying, if a proceeding, and in this case it was a Federal Maritime Commission proceeding, quote, walks, talks, and squawks, very much like a lawsuit, civil proceeding, its placement within the executive branch cannot blind us to the fact that the proceeding is truly an adjudication. And I think that's a really good rule of thumb. So there is very little case law, actually, on access to administrative proceedings generally. And part of the reason for that is that courts will look specifically to the type of proceeding at issue to determine whether or not there's a First Amendment right of access. I think a helpful case to look at is actually a case from the early 1980s that involved access to a Mine Safety and Health Administration fact-finding hearing into a disaster that took place at the Wilburg mine in Utah that it was a fire that resulted in the deaths of 27 miners. The news media, the Society of Professional Journalists, and a number of news organizations were denied access to those fact-finding hearings. They sued, and the federal district court in Utah, agreed that the press had a First Amendment, a constitutional right to attend. In that case, the court looked not only to the fact that the administrative hearings, which were geared towards determining whether the government should impose civil, criminal-like penalties on the operators of the mine, were very similar to a judicial determination or judicial adjudication. But it also focused, and I think that this is critically important, on the fact that openness had benefits. Public transparency had real benefits to the public. Certainly the court focused on the fact that 27 individuals had died, and it was a very emotional situation for the community, and that the community wanted closure in much the same way that they would want closure if there were if there was a horrific crime that occurred. And people want to know what happened. They want to know if someone's being punished, why they're being punished, not simply what the punishment is. And they also would like to know if someone's not being punished or not being punished as severely as people might feel that they should, why that's the case. And so I think it's important to look at the values that are served just generally by openness. I noted that Administrator Dominguez this morning in her opening talk discussed the value of openness in terms of public trust. So it's important that the public and members of the media who serve as sort of the liaison to the public understand why decisions are made in order for them to understand fully, to believe that the proceedings are fair, to see that the proceedings are fair, to have trust that the agency is doing what is appropriate and reaching ultimately the right decision. Even though there's not a lot of case law on these issues, many agencies recognize not only that the public has a right of access to administrative adjudications, but also or administrative hearings where penalties, civil penalties or criminal penalties might be doled out, but also recognize that there's this value in openness. And because of that, even without there being any sort of court case specifically addressing the types of proceedings that their agency is engaged in, there are provisions within their regulations that govern those agencies that provide for public access. Some examples of those include the Federal Reserve Board, whose proceedings are presumptively open to the public, the Federal Trade Commission, the SEC, the Food and Drug Administration, the Department of Labor, the National Labor Relations Board, and the FCC. All of those agencies incorporate essentially a presumption of openness. And I think this is really important because I think it goes to a point that Voss raised. Even in criminal proceedings, and where there's clearly a First Amendment right of access, that right is always qualified, meaning it's not absolute, meaning I can't necessarily get access to every document in a criminal file. There may be redactions that are necessary. There may be portions of hearings that are required to be closed. What happens in those cases is that the judge or the administrative law judge or the neutral arbitrator determines that the First Amendment right has been overcome by a compelling interest that really necessitates closure. That qualified aspect of it addresses a lot of the concerns about trade secret information that might be included in filings that would otherwise be public. I mean, that happens in judicial proceedings all the time, as well as security information, which I can understand is very much a concern. So the fact that the right is not absolute and that even agencies that have incorporated it into their regulations have really followed that model and incorporated a qualified right, a presumption in favor of public access, but not an absolute right of public access. I think I have no time left. So I will be around and happy to answer any questions and continue this discussion. I think it's a really fruitful discussion to be had about how transparency can be not only to hearings themselves, but to documents, and how a proactive disclosure on the part of agencies rather than sitting back and relying on FOIA requests is a really positive thing. So I'm happy to talk about any of those things throughout the weekend. Thank you for having me.